as to modes of losing nationality, and regarding that we will discuss certain important subjects relating to that mode of losing nationality, and in regards to that we'll discuss that citizenship or nationality can be lost either by renunciation or by substitution of one state by another, or when it's deprived by the state itself, or by expiration of stipulated period of residency, or by release, while Germany follows release as a method of loss of citizenship. The American law provides deprivation of citizenship or nationality in the event that 3 years of continuous residence in a foreign state, and that is a valid ground of losing citizenship under American law. The Indian Citizenship Act 1955 provides renunciation, substitution, and deprivation as grounds of loss of citizenship under Section 8, 9, and 10 of Indian Citizenship Act. So these are the various modes of losing citizenship of a state. And now we'll go to another important concept, that is dual nationality. So dual nationality always result out of marriage, and it is being followed in United States of America, France, United Kingdom, and Germany. The Hague Codification Conference of 1930 substantially dealt on the very question of double nationality. So now we'll go to another important subject that is falling under nationality, that is statelessness. So regarding that we will discuss the provisions of Article 1 and Article 4 of the Hague Convention of 1930 on conflict of nationality laws. The Hague Convention of 1930 on conflict of nationality laws dealt specifically the issues under Article 1 and Article 4 of the Convention in view of the Russian refugees in various parts of Europe due to the outbreak of Russian Revolution or the Bolshevik Revolution under the leadership of Vladimir Lenin in 1918, which established a communist state in Russia as Union of Soviet Socialist Republics. So those nationalities and citizens of the then Russia under the Tsar, they left Russian territory and migrated to most of the European countries as refugees. So it was a vital and important subject matter which was raised under the Hague Convention of 1930 regarding the very conflict of nationality laws. And in Germany, an illegitimate child is considered as statelessness. To end the crisis of statelessness, the first International Law Commission took the issue in 1949, and a convention on the status of statelessness persons was held in 1954. And in the same light, the Convention on the Status of Refugees was held in 1953. And finally, a chapter was adopted at Vienna Convention on Status of Refugees in 1951. To carry out and implement the charter in 1954, the United Nations High Commissioner for Refugees was established, and Article 15 of the Universal Declaration of Human Rights in 1948 urges every state to grant nationality to every stateless persons to end the problem of statelessness. And at present, we found, due to the long continuing war and conflict between Ukraine and Russia, so also between Israel, Hamas in the Middle East, most of the nationalities or citizens of either Ukraine or of Lebanon, Syria, Palestine, the various nationalities of West Bank and Gaza Strips are now or refugees in different parts of either Middle East or in Europe, even in some Asian countries. And now it is also very difficult to determine the very issue of nationality as it was under the Hague Convention of 1930 regarding the very conflict of nationalities laws. And at that time it was completely on the Russian refugees after the Bolshevik Revolution of 1918. And at present, even our neighboring country in Myanmar, most of the nationalities and citizens of Myanmar are becomes refugees, and most of them either migrated to India, Bangladesh, or to the neighboring countries. So, at present, also the very issue of statelessness is still continuing, but the 2019 amendment, that is the Citizenship Amendment Act, which was enacted in 2019, most of those religious minorities migrated to India from Pakistan, Afghanistan, and Bangladesh. Such minorities consisting the Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians, those who migrated to India before 2014 were granted citizenship and nationality under this newly amended Act of 2019. In spite of that, there are many such persons or nationalities or citizens we found at present are statelessness, which was to be ended as per the very direction under the provisions of Article 15 of the Universal Declaration of Human Rights in 1948. So, in our upcoming video, we'll discuss regarding the very provisions relating to treaties, whether it is international treaties, multilateral treaties, or bilateral treaties, etc.